All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time and date set for oral argument in cause number CR170182, State of Arizona versus CISNEROS. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal, if you desire. Also, we have read the briefs, we have conferenced the case, and you can assume we are familiar with the facts and the law. At this point, you may proceed, counsel.
Good morning.
Good morning.
Paul Prado, on behalf of the Mr. CISNEROS, the appellant. Thanks for inviting us. This is a Pinson order and an oral argument requested by the court, so I'm intrigued, to be quite frank. Juror 48, and I know he became Juror 10, but for the purpose of the argument, I'll refer to him as 48. He was candid, steadfast, and unequivocal that he wanted to hear both sides. He was repeatedly asked about that. And he said, if he's innocent, or the state has a very, very weak case, I expect him to testify.
No, that's not exactly what he said. He said if there's a compelling argument by the state, then he's going to convict unless he gets something from the defense.
Right.
Is there a difference between a compelling argument and firmly convinced?
I think so.
Well, explain
because
that to me.
What is a compelling argument differs from person to person. And when a person
Well, is it firmly convinced from person
true,
to person?
True, but when a person comes in with an opinion that is contrary to the law, that makes it more difficult to apply that standard.
Well, Mr. Prater, but that's my point, is if we tell a juror that they have to be firmly convinced to convict, and the juror equates that to being compelling evidence, then why isn't it wrong? Why is it wrong for the juror to say, if their state makes compelling evidence, then I expect something else or I'm going to convict?
I understand what you're saying, but he never said, I can put that opinion aside and follow the court's instructions. Not once did he say that, and he was never asked that.
What is he setting aside? If that's the law, that he can rely on compelling evidence to convict, what has he got to set aside?
His opinion that I want to hear both sides. And that's what happened in Hoskins. The court said, you can maintain these opinions of yours, but you will put them aside to decide this case. To me, that is the key.
Well, he didn't respond negatively when they said, could you follow the court's instructions?
And that is a passive response. You don't have to do anything.
Well, that's something the court can consider, right?
Of course they can consider.
All right. And nor did he have a negative response when the court asked him if he would hold it against the defendant if the defendant didn't testify.
Of course he didn't. But when he actually spoke, it's one thing to just sit here and nod, but when he actually spoke, he was very candid and steadfast.
Well, shouldn't we give discretion to the court into making determinations on whether or not that rises to the level of a biased juror?
That's an interesting point, because the court, after hearing this gentleman and not another word from him, included him among the jurors that she was prepared to strike for cause. And then the state argued, well, and the state never went into him wanting to hear both sides of the story. They went to the argument you're talking about. Well, it's compelling evidence, and if we got compelling evidence, you don't have to hear from the defense. I don't agree with that. But the interesting thing is that the court simply said, okay, if you guys can't agree, I'm not going to strike him. And that, I think, in Rubio, is one of the things that Rubio cautioned about in footnote 4. We acknowledge, citing Baker, a potential concern that the cure or waive rule could be seen as encouraging trial courts to deny such challenges more freely, knowing it is incumbent on the defendants to cure any error by using their available peremptory challenge. Nothing happened after he spoke his final words and said, yes, I would hold it against him, that on the record would have changed the court's mind. The court had already decided this person's going, if you guys can agree. It is possible. This is one of the situations where the court's going, okay, I'll let the defense get rid of it.
So let's assume that what you said up to this point is absolutely accurate. That juror was sat, should have been stricken for cause. Now what?
Okay, the juror now appears. Had that juror not served on the deliberating jury, we would be looking at a harmless error standard. And quite frankly, it's a loser. They acquitted on 3 of the counts.
So you're saying that's Hickman?
Pardon?
Or you're saying if the juror did not sit?
If
defense
he was
counsel had used a
impaneled with the
peremptory.
jury, but he was an alternate. Or he was not an alternate.
Okay.
He sat on the deliberating jury. If he had been designated an alternate or for some other reason was off the jury by deliberations, then it would be harmless error review. But he did sit on the jury. And that's why I proposed in the brief, it's structural error.
Would we need to overturn Rubio? Or do we need to disagree with Rubio, I should say?
I think Rubio the courts are going to be fine-tuning it. Just like in Acuna Valenzuela, the Supreme Court.
Let's talk about Valenzuela.
Okay.
Valenzuela is, I don't think, an analogous comparison given the footnote, not the footnote. Let's look at Valenzuela where it sets out paragraph 23. 7 of the 10 peremptory strikes were used on jurors who had been unsuccessfully challenged for cause. So you've got 7. Even if he had used his remaining 3 to remove the jurors he complains of here, there would still be 2 remaining. So he didn't have enough peremptories to strike all of those he thought should have been stricken for cause. That's not what we have here. So why is a peremptory not the proper remedy for a single juror sat over defense objection?
It is a proper remedy. It wasn't used here, obviously.
Isn't that up to trial counsel to define their trial strategy?
Well, quite frankly, when I first looked at this before I got the Pinson order, I'm thinking this is an IAC claim. And counsel blew it. The question is, can we do prejudice? No, we're not going to be able to do prejudice. But we're going to do structural error. Because structural error goes to the integrity of the process, not the outcome. That's why I cited the court to Toomey.
Let's go back to the integrity of the process. Where does the integrity of the process require somebody not to use a peremptory strike if they believe a biased juror is going to be set?
You're changing the question on me a little bit, I think, because what we're talking about is a biased juror being there.
For the purpose of this argument, we're assuming that a biased juror was sat in this case.
Okay, and that affects
And
the
we
outcome.
have one biased juror, unlike Valenzuela, where there were too many.
Yeah.
Okay. So one peremptory used to strike that juror cures any possible error. And I get your IAC claim, but why is it incumbent upon the Court of Appeals to review the beginning of what happened when it could have been cured by defense counsel's
It
action?
could have, but we're talking structural error. And structural error changes the whole ball game. We're not talking IAC. We're talking structural error. Toomey, you had a judge who had a financial interest in convicting people, and the Supreme Court said, if you've got a biased fact finder, end of story, even though the evidence was overwhelming that the guy was guilty. It's not about the evidence.
When we talk about structural error, isn't the peremptory part of the structure and a safeguard to ensure this doesn't happen?
But it did happen.
But it happened, and who knows why? You're saying an IAC claim, I could be thinking trial strategy as that defense attorney. We don't know, and we will never know.
Right.
So why don't we require them to use that peremptory?
Well, first, go back a little bit. I think this issue could have been better handled by a rule change, where you could, in the rules of criminal procedure, where you can get input on all sides as to where are the weaknesses. Like in this case, I think the weakness is an assumption that you waive all error. And I don't think you can waive structural error.
So to get to your point of view and agree with you, we have to agree this is structural error.
Oh, absolutely.
And if we don't, then you lose.
Absolutely.
Okay.
In a nutshell.
That's what I needed to know.
Okay. Is there anything else any other, I know the court had some concerns. You defined the issue, and I've tried to answer it to the best of my ability to help you resolve what concerns you. But Rubio, I think, needs fine-tuning. It's not one size fits all.
Can it be fine-tuned? Do we need to just say we disagree with Rubio?
Well, you can do that, and then we'll have a petition to review to the Supreme Court, and they can decide it, because they have sidestepped this issue a number of times.
So in your opinion, how should this have been handled? First of all, we can all agree that if there's a question, the judge should have stricken the juror. We can agree that if it's a close call, tie goes to the runner, you're off the jury panel.
Yeah.
Once that juror made it onto the jury, what should happen at that point?
Well, what happens sometimes, the judge will say, we've got a juror here that's a problem, and it kind of slipped through the cracks. Why don't we agree to make this person an alternate?
And I agree with that, but in this circumstance, it seems to me that we would have to find that the judge abused discretion in seating the juror, which would necessarily require the judge to be completely unaware that they're committing error, because who wants to do a case twice, right? So given that, whose responsibility is it?
The courts.
Okay, and how do we bring that to the court's attention?
They made a motion to strike.
They did.
Defense counsel didn't use the peremptory challenge, and that's a problem. I understand that. But it doesn't change the fact that a biased juror decided this man's fate. And the law is clear that if you have a biased fact finder, that ends the inquiry. Structural error doesn't go to the outcome. It goes to the process, the integrity of the process.
And I hear what you're saying. But when we talk about the integrity of the process, we have a mechanism to ensure that this doesn't happen, which was not utilized by defense counsel to defendant's detriment in your argument. How is that the court's fault? How is that?
Well,
there was a way to fix it, and
the court could have easily fixed it.
yes. So did defense counsel.
In Hoskins they did it, and Hickman they did it. The court says, now, Mr. Prado, I know that you think this guy should testify, but will you follow the court's instructions? Will you put your opinion aside? And 99% of the jurors are going to go, now the judge is talking to me. It's not a defense counsel or a state's attorney. Of course I'll put it aside. And then all the appellate courts were going to say, there's no error here. It's harmless. He could do it.
No onus on defense counsel to cure it with a peremptory, to make additional records about how he had to use a peremptory because he wasn't stricken for cause, to make a better record. But what we basically have is defense counsel arguing no objection to any, then I object. The only one I had an issue was, sounded like his main issue was, basically said that if I thought he was pretty much, defense didn't present any evidence, he would convict. But if the state had proven his case, we would hold him to that burden. So I don't think there's anything contrary to what the law says on that juror. The court says at this time I'm not going to strike. Shouldn't defense counsel have gone in and made an argument? I mean,
sure, I don't disagree, but Toomey says you don't have to.
Okay.
If the evidence is 100% against him, 100%, you still have to have a fair fact finder, and you didn't.
When we look at the outcome of this, the fact that he was acquitted on a number of charges.
Outcome is irrelevant when you have structural error.
Okay.
That's the entire reason for that when the process has failed. The judge could have easily corrected this.
True. But defense counsel could have corrected
Of course.
So
But
did the process fail or did defense counsel fail?
the process failed because the judge just switched. It said, okay, I'm going to strike this person. Prosecutor says, please don't. essentially. He rehabilitated himself. Judge doesn't say, okay, he rehabilitated himself on this, this, and that. I agree. Upon the record, that man's answers stand that he wanted to hear both sides. We can agree to disagree, and you've got the major vote.
I don't know that we do disagree. I'm just trying to flush out the
Well,
argument
I
to make sure I understand.
I understand. I'm not trying to be facetious or snarky. It's fun to be here.
It's fun to have you, and thank you for accepting our invitation to come.
Okay, thank you.
Good morning. May it please the court, Michelle Hogan with the Attorney General's Office on behalf of the state. This court should affirm CISNEROS' convictions because he waived any theoretical error resulting from the trial court's denial of his for-cause challenge.
Can you waive structural error, though?
I don't know that we have to find whether it was a seating of a biased juror is structural error or not, but yes, you can waive structural error. Batson challenge.
Batson's very different. Batson, that has to do with someone who was kept off the jury. That doesn't tell us that the defendant was tried by a biased jury. It just tells us, yeah, that was unfair. You should have had other people on the jury. But that seems very different. If we had a juror who said, I don't like black people, I'm going to convict black people. Defense objects, and that person sits on the jury. Are we going to say that's not structural error, and we just don't care? Isn't that very different from the Batson situation?
I do agree there are some differences, but it just goes to the point that structural error it's possible to waive it on appeal. And the other example that I can
But
think...
you can waive the right to be tried by an unbiased fact finder?
Under these circumstances...
Let's talk about these circumstances. Defense counsel objects. State argues to leave the juror on there. And we all know that tie goes to the runner, meaning the defendant, get him off. Why isn't it you, not you specifically, but that created this issue in the first place by arguing against a peremptory strike that was rationally based in what the testimony was?
Well, I think that Juror 48's statement was an accurate reflection of the law in that if the state presents uncontradicted evidence that leaves that juror firmly convinced or he takes it as compelling evidence, then he would find the defendant guilty if the defendant didn't present or contradict the evidence. So to me, that is an accurate statement of law, and any confusion...
The juror never said firmly convinced. Compelling evidence is what the juror said. That doesn't match what the jury Rajis are. That doesn't match how we'd explain reasonable doubt. Do you think compelling evidence, which to me equates more clear and convincing? Isn't that compelling, clear and convincing?
I mean, I think we can't expect jurors to express themselves carefully and say the exact legal terms when the trial court had only briefly given them instructions on reasonable doubt, and the defense attorney almost interjected the confusion by not using the correct burden of proof in his questions. So,
but here, didn't the juror essentially say, I expected the defendant to testify? I would expect to see a statement. Isn't that inconsistent? The defendant never has to testify, and this juror seems to be saying, if there's some pretty good evidence against this guy, I'm going to expect that he take the witness stand and testify, or I'm going to convict him. You would agree if that were the line of questioning, you would agree that's error to let the juror sit on the.
It would depend on the full context. I mean, if that was the only question, would you expect him or would convict otherwise?
So assume that's the way. If we were to read that, the juror's statement as being, if there's pretty good evidence against the defendant, and if the defendant doesn't take the stand to testify, I'm going to convict him. If that's the way we read it, where do we go from there? I guess that was Judge Campbell's question to defense counsel. Are you saying Rubio compels us to just say, well, he didn't use a peremptory, so that's tough luck?
Right, I do. I think because allowing a defendant to appeal the trial court's denial of for-cause challenges when that defendant has exhausted otherwise available peremptory strikes on jurors he has not challenged for cause almost unnecessarily rewards trial tactics and embeds a ground for reversal.
But isn't it, I'm not as persuaded that it's a trial tactic. It seems like there's compelling reasons for the defense counsel to strike someone. If it's going to be a close call, defense counsel, the defendant may not prevail on appeal. And so you're running a huge risk. And so if you really think this person is biased, but you may believe that other people who've correctly answered questions, but you disbelieve them if you're the defense lawyer, even though they've said the right things and you feel strongly that they shouldn't be on the panel, it doesn't seem like it's necessarily trial strategy to say, ooh, I'm going to run the risk that this person will be found to have not been biased.
This court should encourage the defendant or defendants generally to use their peremptory strikes on what they consider, I guess, more objectionable jurors, and that they did have an articulable reason for a for-cause.
Should this court also encourage the trial court and the prosecution to agree to excuse someone who's demonstrably biased?
Not even demonstratively. Demonstratively. The state objected to removing this juror for cause. Arguably, this juror was biased or we wouldn't be here. Does the state bear absolutely no responsibility in this circumstance? Because basically we're asking a defendant to burn 1 or 2 or 3 of their peremptory strikes based on the fact that the state is objecting to removal for cause.
Well, I think I'm stressing first, ultimately, it's everyone's responsibility in the trial judge, the state, and the defendant. And that's why both sides get peremptory strikes. Part of it is the reason they have those is to secure an impartial jury and to assist the trial court in securing impartial jury, because the trial judge is making quick decisions on these, and that's why we give these peremptory strikes. And the state did have legitimate reasons for objecting to the for-cause challenge here, because I do think that the juror statements were close in line to law and the law on the state's burden of proof.
And I hear what you're saying, but you will agree with me that it is not as clear as you're making it out to be. When we look at this transcript, we wouldn't be here if juror 48 had been completely rehabilitated by the trial court, by the prosecutor, or by the defense attorney, would we?
No, there is some ambiguity in his statements, but again, the defense attorney could have easily cleared that up by explaining beyond a reasonable doubt and asking if the juror could apply that instruction or would be unwilling, and he didn't. He used some leading type cross-examination questions to get these answers and interjected the confusion there. And
the state didn't attempt to rehabilitate the juror, though, did they?
No. Quickly after that questioning, the trial judge noticed that the jurors were getting confused about the burden because the defense attorney had asked about acquitting the defendant if the jurors were only 51 to 60% certain the crime occurred. Jury 48 didn't raise his hand on that question or indicate any issue with acquitting. But the next question, the trial judge instructed the jurors that the burden of proof is beyond a reasonable doubt. Does anyone have an issue with applying that burden or following the trial court's instruction on that? And juror 48, again, didn't raise his hand and indicate.
But the trial court didn't go into, will you hold it against the defendant if he doesn't take the stand to testify? So assuming there was some good evidence, but the defendant didn't testify, that wasn't neither the prosecutor or no one. The court didn't. I didn't see anything from the prosecutor clearing up any ambiguity about whether this particular juror would feel that it was necessary for the defendant to testify to rebut what was presented.
And I'm not sure that juror 48's statement that if you kind of expect some sort of statement from the defendant, I don't know if he was actually even talking about the defendant testifying or if he was saying that if the state presented a compelling evidence, or then I would wonder, or I would expect something from the defense, otherwise a convict. I'm not sure exactly what he was getting at. It could be any evidence. I'm not sure that he was even stating that he would expect a defendant to testify, because how this individual questioning started was he raised his hand about a preference to hear both sides of the story. I don't think a general preference in real life to hear both sides of the story indicates he would expect a defendant to testify, and or that he would disregard the trial court's instructions over that.
Let's listen to what he said. Juror 48 says, if the state presented a compelling argument and the defense side did not defend themselves, it would lead me to believe the defense was guilty.
Right. And again, if the state does present uncontradicted evidence, I think that would also be a legitimate argument and closing argument for the state to make. We presented uncontradicted evidence that's argument.
The next part goes down, though, and says that would probably be okay for me if they didn't actually present a statement. Statement seems to be referring to, what else would that be referring to other than a statement by the defendant, testimony from the defendant?
I'm not sure what exactly he was getting at. There is some ambiguity, but I guess it could mean another witness. I'm not exactly sure what he meant. Some evidence or cross-examination. I just don't know from this record exactly what he was getting at with that.
Could I ask to change gears a little bit? Rubio seems a little bit inconsistent with the cases you've cited, I think in the footnote in your brief that notes that the Arizona Supreme Court will review a claim that the Superior Court failed to sua sponte strike a biased juror. Why would there be a need to review to determine whether the court should have sua sponte? By saying that, they're necessarily implying that that defense counsel didn't exercise a peremptory, didn't object. So how is that consistent with Rubio?
Well, most of those cases came out before Rubio. There was one that came after, I think it was Cruz. I can't remember the exact name, but the Supreme Court did apply fundamental error review there. The state didn't argue the cure or waive rule below or in its briefing, so I just don't think it was a rejection of the cure or waive rule at all. It just happened to be that the state didn't argue it, so they used what the state was arguing is this is reviewed for fundamental error.
But the Supreme Court hasn't actually adopted the cure or waive rule, correct?
No, but in Acuna Valenzuela, I think the Supreme Court implicitly...
Well, they just said regardless, they said we don't get there because you couldn't have used all of them to get rid of all of them. We don't know which ones they would have struck, so... Right.
The reason we're not applying the cure or waive rule here is under these circumstances.
Can we talk about that for a minute, the cure or waive rule? Let's assume for sake of argument that you have a juror that unquestionably makes a statement during voir dire that they're biased. And we'll say, well, we have 4 jurors that have said it. And for whatever reason, the judge is asleep at the switch and doesn't grant the defense motion to strike these individuals. So we're adopting a rule that says the defense has to remove these obviously biased individuals from the panel, so they would only get 2 strikes. But the state gets to use all 6 of their strikes. Is that fair? And does it survive a due process argument?
Yes.
Say one side only gets 2 and the other gets 6.
Yes, because peremptory strikes aren't of a constitutional dimension.
That just tells us you're not necessarily entitled to them. But if we do grant them, can we say we're going to give the state 6 peremptory strikes and we're only going to give the defendant 2 peremptory strikes? They're not constitutionally mandated, but would that survive a due process challenge?
Yes, because not only are they not constitutionally, but also because
could we adopt that as a rule and that says the state gets 10 peremptories, the defendant gets 3?
And you put it in case law or in
let's say it's
statute?
a rule of criminal procedure that says the state gets 10 peremptories, the defendant gets 3. Would that survive a due process
in
challenge?
that case, it does seem unfair that the state would get more.
How is that different than Judge McMurtry's hypothetical where there's clearly 3 jurors who should have been struck for cause. Isn't that the result, the same result?
Well, the defendant doesn't have unfettered discretion over these. Sometimes you're going to have to use these to strike jurors who should have been stricken for cause. So I think that's the difference, is that we're granting these, but you're not always going to have unfettered discretion over these. Sometimes you're going to have to use them for jurors that have not been stricken for cause that should have been.
Does the state bear any responsibility in ensuring that the defendant receives a fair and impartial jury panel?
I do think it's everyone in the jury selection process, the trial judge, the state, and the defendant all bear burden of selecting an impartial jury.
You would agree with me we wouldn't be here had the state in this case not objected to striking that juror for cause.
Right, because then the juror would have been removed for cause and there would be no issue here at all to raise.
Correct. So how much of this should the onus be on the state? I mean, we've already placed a huge onus on the trial judge, who is one person in a room full of people that's listening and trying to do the best to ensure people's constitutional rights are adhered to. Should the prosecutor bear any responsibility for that?
The prosecutor has responsibility, but these weren't. It wasn't a meritless objection. I mean, there was good grounds for the prosecutor's objection. So I don't, and I think.
But in other contexts, if the prosecutor objects when the defense asks to exclude evidence and the prosecutor says, no, this evidence should come in, and if the prosecutor just makes a mistake, or if the evidence should not have come in, we don't say, well, that's, even if they had a good faith basis, if the court ultimately determines, no, that evidence should not have been admitted, then don't we give the defendant a new trial if it was prejudicial evidence?
Right. I mean, evidentiary issues are, I think, very different from jury selection.
Let's talk about jury selection. So, wouldn't the adoption of the Cure waive requiring preemptory challenges to be used, and it would be only the defendant that would have to use them typically in the usual course of business? So, aren't we encouraging the state to object to anybody that's right on the line because they're going to have to use their preemptories to get rid of them, and the state still has all of theirs?
Again, I don't think that type of trial tactic is going on. The state does want to ensure that there is a fair trial and doesn't want grounds for an appeal. And I think I don't think it's necessarily that there's just close grounds. And here, this case, I don't think it was that close. I know there's disagreement on that.
If we go back to Rubio for a second, in Rubio, the Court of Appeals relied in part on, as persuasive, Utah case.
Right.
Utah since said that's not a good rule. Should we also say that's not a good rule, and disagree with our colleagues on the Court of Appeals as it relates to Rubio?
No, I mean, other states have, and I did say it to other states that have adopted this rule. And
but the one Rubio relied on was Utah, and the other states seem arguably distinguishable. The Utah case seemed most closely on point, and the Utah Supreme Court has just said no, and they even said it in a civil case where there's arguably less
due process
that's owed to the defendant. So why shouldn't we consider the Utah Supreme Court's more recent decision?
I think the reasoning in Rubio is legitimate in that we should encourage defendants to help the trial court in securing an impartial jury, and that not necessarily having unfettered discretion over peremptory strikes, and that they're going to have to use these to preserve an issue on appeal.
That's kind of, the Utah Supreme Court just said, well, we don't think there's really a powerful incentive for the defendant to leave somebody on there, and they just disagreed with that rationale. And Rubio seemed a little bit different. It was just the juror had worked in the same office. It's different than somebody saying, I don't like black people, or where there's it's clear that a juror is biased, and that seems pretty structural to be tried by a biased fact finder.
to me, the nature of the error doesn't change depending on whether the bias is based on a work association, like in Rubio, or whether it's stated on an.
But that's not a clear bias if you're just saying, well, anyway, if you just said, I used to work at that office. That doesn't necessarily tell me something. But regardless, if we were to just disagree with Rubio and say that there's structural error if, in fact, a biased fact finder.
Right.
There is a biased fact finder.
And I did give the example of a Batson challenge. You can waive structural error in that instance. And I also the right to a public trial, which if violated.
And you're not being tried by an unbiased fact finder. Even if it's not a public trial, you're still being tried by a fair, presumably, fact finder. And same as if some of your Batson challenges have been rejected, the people who are actually sitting on your case are presumably fair and unbiased.
And there's still an available remedy if there was truly a biased juror, and that is that Rule 32 proceeding where the trial court can have the trial attorney make a record about why he left a clearly biased juror on the panel. And if it's so bad, I mean, that could be referred to the state bar. So it seems like that would be the better means to address that type of error. See, I'm out of time. Thank you.
Counsel.
Absent any questions from the court, I've said my piece.
Thank you.
Thank you, Mr. Crader.
All right. Thank you both for your arguments. We will take this matter under advisement and issue a written ruling in due course. Thank you, counsel.